First testifier. Professor Lynn Wardle is going to come up and testify.
Come on up, Lynn.
Lynn, please front and center. A bit of the background of Professor Wardle. He's a professor at BYU, a graduate of the Duke Law School of North Carolina, and a president of the International Society for Family Law. He's been a visiting professor and made presentations in, it says, over 20 countries. So you're going to do this in English then, right, Lynn?
Yeah.
And he's published numerous articles and books, too numerous to mention. And one thing that distinguishes him is that he was a law clerk for Judge Sirica. Those of you who have a few gray hairs will remember Judge Sirica was in the Nixon White House at the time. He was the judge who, with the Nixon tapes, ordered the tapes, and it was from there that the Nixon White House went down. Did you give him that idea, Lynn, about subpoenaing the tapes? Because that was a
I was there during the cover-up.
Okay. So, Lynn Wardle, and he's got to get on a plane, so please, without any further ado, Professor.
You just share us with us your opening comments. You've obviously read the bill. I'm sure you've looked at the latest iteration, although not as closely as some of us, because you probably didn't get it, but it closely resembles. So why don't you start with your opening statement?
Thank you very much. I'm deeply honored to be here before this distinguished committee.
Pull the mic closer.
And hope that I can provide information that's useful, and please feel free to ask questions at any time. My special emphasis in my education and experience is family law and procedural questions, including the jurisdiction for divorce. The provision of the proposed provision raises red flags if it's not facially unconstitutional. It certainly has serious problems, and I'll come to that in a moment. But I commend you for your careful attention to these issues. They're very important, and it's not just academic. What you're dealing with is will have a profound impact through the generations. Today I speak for myself. I'm not representing any of the institutions I'm associated with. More than 3 decades of experience as a family law professor has taught me the importance of tolerance and respect for different family forms, but it has also taught me the importance of preserving the basic and core institutions, and marriage is the most basic and core institution. The bill before the legislature would redefine marriage in a very significant way that I think could be unconstitutional and bad policy in several regards. And I'm going to make 7 points in my presentation, and I'll just summarize them up front because time may not permit me to go in fully, and I'll make my written statement available.
Please.
First, same-sex marriage is contrary to and inconsistent with the law of the meaning of marriage in over 92% of the nations on the face of the earth and over 70% of the states in the United States. Same-sex marriage is legalized, is recognized and allowed in only 7.8% of the nations on the face of the earth. Second, legalizing same-sex marriage could impair recognition of Hawaiian marriages, and not just Hawaiian same-sex marriages, but other marriages from Hawaii may be called into question as a result of policy concerns rising out of the legalizing of same-sex marriage. We've seen that historically, going back to Hyde versus Woodmansee, a British case in the 1860s. Third, the proposed radical extension of divorce jurisdiction, allowing a state, Hawaii, to grant a divorce to people domiciled elsewhere whose only connection with Hawaii is that they came here to get married, flies in the face of existing Supreme Court precedent on what is required for a state court to have jurisdiction to grant a divorce. Fourth, the same-sex marriage bill jeopardizes religious liberty in significant ways, and I talk in my paper about both negative and positive. That is, it's deficient negatively in failing to provide exemption within the context of the bill, and positive deficiency in that it doesn't protect or establish the protected status of the exercise of religion by individuals in this state and by organizations. Fifth, the bill endangers the best interests of children by altering the marital presumption in ways that could create all sorts of controversies, including multiple parentage, not just a mom and a dad, but 3 or 4 parents. All children deserve to have and be raised by, whenever possible, a mother and a father. 2 mothers and 2 fathers isn't the same thing. The question comes down to gender. Are gender differences relevant to the purposes of marriage? If not, this bill is uncontroversial. But because men and women are different in ways that relate to the essential purposes of marriage and marital families, those differences need to be recognized. The law simply can't erase them. The bill also is inconsistent with Supreme Court precedents that have long recognized the critical importance of marriage as the foundation of our society. And I believe the bill misrepresents and strains the Supreme Court holding recently in the Windsor versus United States case. The key point that I want to make can be summarized with a story from Abraham Lincoln's life. He was being heckled once, and Lincoln turned to the heckler and said, "How many legs does a calf have if you call a tail a leg?" And the heckler said, 5. And Lincoln said, "No, calling a tail a leg doesn't make it a leg." When there are critical and basic foundational differences, merely changing labels isn't going to give the results that the label is traditionally given when limited to the nature of the institution. Calling same-sex unions marriages will not confer upon those relationships the benefits that come from the gender integration of a man and a woman in the union that we call marriage. I'm going to skip over the most of this so that time would remain for questions to be answered. I'm a law professor, which means that I can speak for 50 minutes without batting an eyelash, and I know that isn't what I'm here to do. I'm not here to lecture, but hopefully to provide information and, if necessary, to answer any questions that might be of help to you. So
Politicians can exceed 50 minutes.
Oh, is that right?
They filibuster.
Okay, well, I will try not to filibuster on this occasion. I just will point out that nearly 40% of the people that live in Hawaii have some Asian background or heritage. None of those nations recognizes same-sex marriage, and another 10% nearly are from Pacific Island backgrounds. None of the Pacific Island nations allow same-sex marriage. I guess New Zealand might be an exception if you now count their recent law. But this is out of step with 178 nations of the earth reject and do not allow same-sex marriage. So this is going to create a possibility for conflict. And I want to talk about, because I'm a family law professor, I'm going to skip religious liberty. There are serious problems, incidents that have arisen in states where same-sex marriage has been legalized, but others panel speakers, I believe, will address that. But my background in family law leads me to have grave concern about the message of the law and the image or the concept of marriage that is conveyed by the law that in some way diminishes and reduces the value and the respect of that institution and of the contribution of men and women to that institution. Recent studies have documented significant advantages to children that are raised by their biological mom and married mom and dad, and the national authority on that is with us today with Professor Rick Naris, and I will not talk about that because that would be sort of like someone talking about a heavy rain in the presence of Noah. They understand a
Yeah.
little better about flooding. So let me move on to the value of marriage. Marriage isn't a private relationship, but is a public trust. Those who enter into marriages undertake public responsibilities. It is a public institution. The Supreme Court noted that marriage gives character to our whole civil polity. It's the foundation of family and society, without which there would be neither civilization nor progress. It emphasized that marriage involves interests that are of the basic importance to society, according to the court, because it relates to the state's interest in the stability of their social order and the good morals of their citizens and the needs of their children. States have particular interests in the kinds of law that regulate their citizens when they enter into, maintain, and dissolve marriages. Marriage is society's infrastructure. Aristotle famously taught that it was the foundation of the republic, marriage. And both Aristotle and Plato described a set of family laws defining the ideal ages and conditions and qualities and duties of marriage. They said that's the first thing the legislator does, is establish the rules that regulate marriage. So it's the wellspring of social capital in our society, and I think it's incredibly important that while we respect, the question is, can you respect other forms of relationships, polygamous, polyamorous, and same-sex, without calling them marriages? And the answer is yes, of course we can. But do you have to redefine the basic institution of society in order to give respect to other kinds of relationships? No, that's a flawed argument. So I think that I will stop at this point, and the people of Hawaii, I believe, are family friendly. I think this bill is not family friendly. I think it has many flaws. The religious exemptions are incredibly narrow and not very generous, inconsistent with the purpose of protecting religion. So I will stop here and ask if there are any questions you might have for me.
Would, Tom, you want to ask some questions? You've got to leave soon?
Oh, no, well, I thought I should keep an eye on Karen, so I was going to say.
Okay, yeah, okay.
No, but please, no. Just thank you for your time, and these are, very important pieces of information. One of the reasons I came tonight is because a handful of people have come to my office, and out of respect, I wanted to come and further learn about the issues. But thank you, and I'll let you ask questions.
Richard, do you have any questions?
I have a few.
Pull the mic.
Microphone.
I have a couple questions. Let's start with the first one. In one of the bills, it talks about rights of parents. Okay, and it talks about that in the case of a same-sex marriage, these rights, benefits, protections, and responsibilities shall include paternity, maternity, and parentage presumptions based on marriage. Okay. What are the parentage presumptions based on marriage? What is that referring to? What does that mean?
Well, the first thing that comes to mind is the presumption that the husband of the woman who bore the child is presumed to be the father. That's the parentage presumption. That obviously is not true if the husband is a woman, if the same-sex partner is, but that's a presumption that goes way back in common law. It's one of the few things they could be, they were willing to presume.
The reason why I asked that question is that here in Hawaii, Native Hawaiian rights is something that's very important here in the state. And in the case of a same-sex couple where, let's say, two females that are married, and one is Native Hawaiian, one is non-Native Hawaiian, and then the non-Native Hawaiian spouse in that relationship becomes pregnant with a non-Native Hawaiian father, or father, I guess we'll just call it father in this case. in that, under the paternity, under the parentage presumption, when that child is born, the spouse is automatically presumed to be the parent of that child, and therefore, on that child's birth certificate, would you automatically write Native Hawaiian in that case? When, in the case of the two mothers, the non-Native Hawaiian becomes pregnant, has a child with a non-Native father, but under the law as it's written right now, the child, even though there isn't any Native Hawaiian blood in that child, it would automatically be written as Native Hawaiian under the current system that we have, and that child would be entitled to all the benefits that are given to Native Hawaiians. Would that be an accurate assessment?
I'm not familiar with that law, but I do have the language of this bill in front of me, and it says parentage rights, benefits, protections, and responsibilities based on marriage shall be the same for all married persons, regardless of the gender of the spouse. The phrase shall be the same implies the hypothetical dilemma that you've raised here. So you don't know how it would be resolved until a court, it was brought before a court. But the language shall be the same certainly seems to be very strong and would raise that implication.
So would this undermine Native Hawaiian? Would this undermine a number of the Native Hawaiian foundational rights that we...
It could. I'm not familiar enough with Native Hawaiian special protections, but inasmuch as it uses the term shall be the same, it could have application in that context that certainly would produce unintended and undesirable consequences.
I just want to, while we have him here, Jim, would you just come over to the microphone and amplify that answer as you understand it? What Richard was saying, parent A, parent B, one is Native Hawaiian, one is not. The non-Native Hawaiian gives birth. Will that child be able to qualify for homestead, Kamehameha schools, all these other benefits that are reserved for Native Hawaiians?
Well, see, those are the rights that Representative Foley was talking about. And the language that the professor is drawing our attention to, shall be the same, indicates that those claims can be made by those non-Native Hawaiian children.
Okay. Thank you, Jim. We're going to call you to pinch hit whenever we get in trouble, okay?
Sure.
Okay, thank you.
The language of this, though, is focusing on the adult rights, not the child's rights. I'm not sure how it would play out in interpretation, but it's the ambiguity and the breadth of that shall be the same language that is potentially problematic.
Anything else? Karen, do you have some questions?
Thank you. So in the, just as a follow-up to Representative Foley's question, so on a birth certificate in countries where, or states where they accept same-sex marriage, does it read mother-mother or father-mother, or how does it read on the?
I don't know. I've not looked at each of those, but at one point I saw one that said parent A and parent B.
Thank you.
So yeah, again, the implication is that somehow fatherhood and motherhood are old-fashioned and sort of generic androgynous parenthood is all that matters, is troubling, because there's something valuable that is lost when the gendered parenting role is brushed aside and replaced by some neutral concept.
Thank you, Professor, for your words. I have a question more about, I guess, the industry of family law, particularly when it's so new. How do you draw conclusions or precedents without a big basis of empirical data, or at least a case history of 10, 20, 30 years? Where are we in terms of this whole new marriage law?
That's a very good question, and the answer is all you can do is apply the established and tried and true methods of interpretation and analysis to give the best prediction of how the language will play out in particular cases. But we don't know. This is such a new institution. It's newer than our computers, and
But it's always been around. I mean, it's nothing new.
homosexual relations
Yes,
have
but never legally ever codified.
never treated as marriages, even in cultures in which homosexuality was tolerated, accepted, embraced, sort of part of the accepted social experience. They said, this is different. We don't call that marriage because marriage exists for a different purpose, to unite the genders, to integrate the genders, whereas homosexual relations have a different purpose.
So how long would it take, would you estimate, before we know the impacts, the empirical evidence of whether all these variables of family, children, divorce, all of the other phenomena?
I think that we already can see some of the impacts resulting from this, even in the short experience that we have had with just 16 or 15 nations and 13 or 14 states, 14 now with New Jersey. We very short-lived, but we can already see some of the impact. One of the critical areas of impact is in legalizing same-sex marriage, frankly, is education. I haven't even touched on that. But what do teachers teach in schools when they talk about marriages? What are the concepts of marriage that are socialized into the minds of those children when we've legalized same-sex marriage? The teachers are agents of the state. They have to embrace and present and convey the state's concept of marriage. That can be very problematic and very troubling, and has proven to cause all sorts of problems. Certainly California is a seedbed of those examples of those problematic incidents.
I have a quick question for you, and I know you have to catch a flight. The divorce issue, you mentioned that very problematic in the bill. We might become the divorce clearinghouse for the mainland, because there's no residency requirement here in that, as I understand it.
Well, there are several problems. The one that I was specifically referring to in the bill is that the provision that gives Hawaii courts jurisdiction to grant divorces to couples who are not domiciled in Hawaii. The Supreme Court cases going back for nearly a century, going back 70 or 80 years at least, have said domicile is required, or some domicile-like strong connection, strong, long presence and commitment to the state is required before the state courts have jurisdiction to grant a divorce. This says, no, if you were just here for a weekend marriage and flew back, our courts have jurisdiction to dissolve that marriage. On its face, that appears to fly contrary to all of those established cases that said, we're not going to let states get into tiffs and tussle and wrestling matches over who gets to divorce each other's citizens. You've got to have a strong connection with the state before the state has enough interest to dissolve the marriage. Domicile is the connection, not the mere fact that you went someplace and got married in a weekend. That doesn't, the jurisdiction required to create a marriage is very light, very simple, very low standard. The jurisdiction required to dissolve a marriage is very high, very strict, because the consequences from marriage dissolution are so profound on the society. What society? The society where the family lives, where the couple lives. So the court has said, you've got to have domicile, and this statute says, well, we've got an exception. You don't have to have domicile if they got a same-sex marriage here. I think that's very
And one of the reasons I would assume that there is a domicile requirement is because a divorce proceeding is a substantial cost, correct?
substantial cost to the state and substantial cost in non-financial terms to the state and to the children, to the family. It has long-term costs that are non-economic in terms of social, and it's a profound transformative experience for children. So only the state where those children are domiciled, live with their family, their parents are domiciled, has sufficient interest to dissolve that marriage.
And we have to move along here briefly, but one of the things that we're told is if we pass same-sex marriage, it'll be a boon to tourism. So people will come here and get married and go back to, say, Wisconsin or Pennsylvania, wherever the heck they're from. And then they want to get divorced, they come back here, they don't have a residence here, they clog up our court system, which causes an increase in the tax burden or tax fiscal responsibility for the rest of the citizens who live here, our local people. You see that as a possible scenario?
Well, I see that as an unavoidable scenario. First of all, I think the divorce would lack jurisdiction, and other states would not have to recognize the divorce as a valid divorce. Second, coming here would indeed give costs to the local court system. Somebody's got to pay the judge. Somebody's got to pay the court clerks. Somebody's got to pay for all the filing and the processes. And the court filing fees don't cover that, don't even come close to covering that. So, yeah, it could be costly.
Tom, do you have some questions?
Last question, Tom Brower.
Representative McDermott, let's not bring Pennsylvania into this. It's unfortunate in some ways that the federal government couldn't decide this issue, and we have to do it 50 different ways throughout the states. But do you think it would be better, Professor, to allow the issue of same-sex marriage to be decided by Hawaii's courts or Hawaii's legislature? Couldn't the legislature provide more protections for the religious community?
Oh, absolutely. As between the courts and the legislatures, clearly the legislature is the body that should be making this policy decision, because you are elected by and accountable to the people of Hawaii, and the courts are independent. For a very important reason they're independent, but that independence makes them less qualified, indeed disqualified, to make these kinds of profoundly important policy decisions that affect the whole polis, the whole community. Yeah, the legislature, I commend you for addressing, thinking about the issues. This is the body that should do it. I just don't think this bill is a very good bill.
My good friend and connoisseur here insulted the 51st state, Kentucky, Pennsylvania. But the
I'm ignorant.
well, I've never been called that. But
you haven't been around here long enough. Stick around.
No, I don't. But the legislature is a great place to decide it. But isn't it even a better place to decide it? Let the people decide.
I concur completely. As a government body, among the government bodies, the legislature is the closest to the people. But 31 states have brought this before the people by constitutional amendments. One of the first was Hawaii, and its resolution was the courts cannot decide it, the legislature should decide. That was correct, as between governmental bodies. But the other 30 states, including California, until it was struck down by Judge Von Walker's strange decision in the Perry case. But the other states have simply addressed the merits of the issue. What is the meaning of marriage? And most of them say marriage is the union of a man and a woman. Some of them go beyond and say marriage is the union of a man and a woman, and we will not allow any other civil or domestic relationship to be treated the same as marriage, whatever label you put on it.
Okay. Seeing no other questions, thank you, Professor.
Thank you for
Thank you.
coming
It's
out
been
here.
an
We
honor for me
appreciate it.
Good trip
speak
back.
here.
Yeah.